Federal marshals hit 17 Trump properties at 6:47 a.m. Eastern Standard Time. Not routine inspections, armed seizures, $2.3 billion in real estate assets now under direct federal control following a court order that legal experts are calling unprecedented in scope and devastating in execution. Security footage from Trump Tower, Manhattan shows federal agents methodically changing locks on executive floors, while armed marshals establish perimeter control. The image of agents posting seizure notices on gold-plated doors sends a message that no amount of wealth provides immunity from court-ordered enforcement. Think about what that means. While you're watching this unfold from wherever you are in the country, comment below and tell us your location as we witness something that has never happened before in American politics. The systematic dismantling of a former president's empire is happening in real time. According to sources familiar with the coordinated operation, federal marshals received their orders at 4:30 a.m. and moved simultaneously across multiple states. Trump Tower, 40 Wall Street, Seven Springs Estate in Westchester, and Mar-a-Lago all came under federal control within a 2-hour window. This isn't a symbolic gesture. This is the enforcement mechanism of a court system that has run out of patience. The judge's 47-page fraud ruling, obtained exclusively by federal investigators, doesn't just order seizure. It establishes a framework for liquidation that could strip Trump of every major asset he owns. When federal authorities describe an operation as having no precedent in scope, that means we're witnessing the collapse of what was once considered an untouchable financial empire. Here's what makes this truly devastating. These properties aren't just real estate holdings. They're the physical foundation of Trump's political brand, his business operations, and his personal identity. Federal agents aren't just seizing buildings, they're dismantling the infrastructure of power that took decades to construct. The speed of execution tells the complete story. Courts don't authorize dawn raids and simultaneous multi-state seizures unless they've determined that standard enforcement methods have failed completely. This level of federal response signals that legal accountability has moved from theoretical possibility to immediate reality. Watch what happens next. Federal marshals don't change locks and post-seizure notices as a negotiating tactic. They do it because a judge has determined that $2.3 billion in assets must be secured immediately to satisfy a fraud judgment that Trump can no longer appeal, delay, or escape. The seizures didn't happen overnight. This systematic dismantling began with a single court ruling on February 16th that changed everything. Judge Arthur Engeron imposed a $454 million fraud judgment that legal experts immediately recognized as a financial death sentence. Trump had 30 days to secure a bond. He failed spectacularly. According to sources familiar with the bond process, 30 different surety companies rejected Trump's applications, not because they questioned his ability to pay, but because they couldn't verify the legitimacy of assets he claimed as collateral. When insurance companies that routinely handle billion-dollar bonds refuse to touch your case, that's not a paperwork problem, that's a credibility collapse. The timeline reveals everything. March 18th, Trump's lawyers filed for emergency relief. Denied. March 25th, they attempted to negotiate a reduced bond amount. Rejected. April 1st, they proposed a payment plan. Court response was immediate and devastating. Pay in full or face enforcement. No exceptions, no delays, no special treatment. Here's where it gets truly significant. New York Attorney General Letitia James didn't wait for appeals to exhaust. She began asset identification procedures while Trump's lawyers were still filing motions. Properties across Manhattan, Westchester County, and Florida were cataloged, appraised, and prepared for seizure. The methodical approach demonstrates a legal strategy designed to prevent asset hiding or transfer. Trump Tower, Manhattan, valued at $540 million, 40 Wall Street, assessed at $350 million, Seven Springs Estate in Westchester, worth $290 million, Mar-a-Lago in Palm Beach, appraised at $180 million, golf courses in New Jersey, New York, and Scotland totaling $410 million. The Attorney General's office identified $2.3 billion in seizable assets before Trump even knew enforcement proceedings had begun. Legal experts watching these developments describe the coordination as unprecedented. Professor of law at Columbia University Sarah Mitchell stated, "We've never seen state and federal authorities move this efficiently to secure assets of this magnitude. The speed indicates months of preparation and interagency coordination that suggests they anticipated exactly this scenario." The desperation became obvious when Trump's legal team proposed using Truth Social stock as collateral. According to bond specialists familiar with the proposal, using volatile social media company shares to secure a fraud judgment bond violated basic underwriting standards. When your lawyers suggest using meme stock as collateral for a $500 million bond, you've run out of legitimate options. Think about what that sequence reveals. Every traditional avenue for wealthy defendants to delay enforcement was systematically eliminated, appeals denied, bond applications rejected, payment plans refused, asset transfers blocked. The legal system demonstrated that decades of litigation strategies designed to outlast prosecutors had finally met their match. By May 15th, federal marshals received operational authority to begin seizures. The timeline from judgment to enforcement took exactly 90 days. In white-collar fraud cases involving comparable amounts, enforcement typically takes 18 to 24 months. This accelerated schedule signals judicial determination that normal delays would enable further asset concealment or transfer. The Attorney General's office made their strategy clear through court filings obtained by federal investigators. Quote, "The defendant has demonstrated through decades of behavior that standard enforcement mechanisms are insufficient to secure compliance. Extraordinary measures are not only justified but necessary to prevent systematic evasion of court-ordered penalties." That's not legal opinion. That's a judicial finding that Trump's track record of avoiding consequences required unprecedented enforcement measures. When courts conclude that normal procedures won't work with a specific defendant, they authorize the kind of coordinated seizure operation we witnessed at dawn across multiple states. The fraud wasn't subtle. According to internal Trump Organization documents obtained during the investigation, property valuations were systematically inflated by 200 to 400% across 2 decades of financial statements. This isn't estimation error. This is deliberate deception designed to extract maximum financial benefit from banks, insurers, and investors who trusted the numbers. Mar-a-Lago provides the clearest example of systematic fraud. Trump valued the property at $739 million on financial statements submitted to Deutsche Bank. The actual assessed value, according to Palm Beach County records, was $18 million. That's not a miscalculation. That's a 4,000% inflation of asset value to secure loans that legitimate valuations would never have justified. The pattern repeats across every major property. Trump Tower penthouse was listed at $327 million on loan applications, while comparable sales data showed a maximum value of $80 million. Seven Springs Estate claimed $291 million in value, while county assessments placed it at $56 million. 40 Wall Street appeared on financial statements at $540 million despite generating rental income consistent with a $200 million valuation. Judge Arthur Engeron's ruling describes these discrepancies as representing persistent and systematic fraud that demonstrates a complete disregard for accurate financial reporting. The court found that Trump Organization executives knew the valuations were false, approved their use anyway, and implemented internal procedures designed to prevent outside verification of actual asset values. Internal emails obtained through discovery reveal the deliberate nature of the scheme. Chief Financial Officer Alan Weisselberg wrote to accounting staff stating, "We need the numbers to work for the loan requirements. Adjust valuations accordingly and ensure supporting documentation reflects necessary figures." That's not ambiguous language. That's explicit instruction to falsify financial records. The obstruction continued throughout the investigation process. According to sources familiar with the proceedings, Trump Organization lawyers delayed document production for 18 months, claimed privilege over basic financial records, and required court orders to produce materials that standard discovery requests should have secured immediately. When defendants fight this hard to prevent evidence review, they're not protecting legitimate business interests. They're concealing systematic wrongdoing. The judge's findings on Trump's testimony reveal the extent of deliberate deception. Quote from the court ruling, the defendant's sworn statements contained numerous factual inaccuracies, contradicted documented evidence, and demonstrated a pattern of evasion that undermined the credibility of his entire defense. When a federal judge concludes that sworn testimony is systematically dishonest, that finding becomes part of the permanent legal record. Deutsche Bank executives, speaking on condition of anonymity, confirmed they relied on Trump's asset valuations for loan decisions totaling $340 million. Had accurate valuations been provided, according to internal bank communications, loan approvals would have been denied or structured with significantly different terms and interest rates. The bank's losses from this deception are now subject to separate federal investigation. Insurance companies reported similar experiences. Zurich Insurance relied on inflated property valuations to calculate premiums for $560 million in coverage across Trump properties. The misrepresentation resulted in below-market premiums that failed to reflect actual risk exposure. Industry sources describe this as one of the largest insurance fraud schemes they've encountered in commercial real estate. The judge called Trump's defense strategy completely without merit after reviewing evidence that included manipulated appraisals, altered financial statements, and testimony that contradicted documented facts. Legal experts familiar with fraud cases describe this level of judicial criticism as extremely rare and indicative of evidence so overwhelming that reasonable defenses become impossible to construct. This systematic deception enabled Trump to secure loans, insurance coverage, and financial benefits totaling over $1.2 billion across 2 decades. The fraud wasn't a one-time mistake or aggressive business practice. It was a deliberate, coordinated scheme designed to extract maximum financial benefit through false representations that no legitimate business would attempt. The seizures are happening everywhere at once. Trump Tower Manhattan, the golden fortress of the Trump empire, sits under federal control as armed marshals maintain 24-hour security protocols. Executive floors that once hosted million-dollar deals now display court-ordered notices prohibiting access to former occupants. The building that defined Trump's public image for 4 decades has become a symbol of judicial enforcement that no amount of wealth can circumvent. 40 Wall Street tells a similar story of systematic dismantling. Federal authorities have taken operational control of the 72-story office building, freezing rental income that provided $25 million annually to Trump Organization coffers. Commercial tenants received notices that lease payments must now be directed to court-appointed receivers. The building that Trump once called his crown jewel of Manhattan real estate generates zero revenue for his organization as of this morning. Mar-a-Lago represents the most devastating blow to Trump's personal operation. Federal marshals have restricted access to the Palm Beach resort, effectively ending its function as both private residence and commercial venue. The resort that generated $37 million in annual revenue from events and memberships now operates under court supervision, with all proceeds directed toward satisfying the fraud judgment. Social events scheduled through December have been canceled, resulting in immediate revenue loss and contractual penalties. Golf course operations across 3 states face immediate closure threats. Trump National Golf Club in New Jersey, Trump International Golf Club in New York, and Trump Turnberry in Scotland all received federal notices freezing operational accounts and restricting access to management facilities. According to sources familiar with the operations, 847 employees received preliminary termination notices as court-appointed receivers evaluate which facilities can continue operating under federal supervision. The international implications extend far beyond domestic property seizures. Swiss banking authorities confirmed they received federal requests for information regarding Trump Organization accounts at Credit Suisse and UBS. British authorities reported similar requests concerning Scottish golf course operations and offshore holding companies. When federal enforcement reaches international banking systems, it signals coordination between multiple governments to prevent asset transfer or concealment. Trump Organization employees are experiencing immediate career devastation. The company's Manhattan headquarters eliminated 156 positions yesterday as federal receivers determined that normal business operations could not continue under court supervision. Senior executives who spent decades building the organization's operations received termination packages that may never be fully paid due to asset freezes affecting corporate accounts. The 2024 campaign feels direct financial pressure as primary funding sources disappear overnight. Truth Social stock, which Trump used as collateral for previous legal expenses, has lost 68% of its value since seizure announcements began. Political action committees that relied on Trump Organization venue rentals for fundraising events face immediate relocation costs and contractual obligations they cannot fulfill. Real estate markets and luxury segments are experiencing immediate volatility as forced liquidations threaten to flood Manhattan with premium properties. According to industry analysts familiar with the Trump portfolio, court-ordered sales could depress luxury real estate values by 12 to 18% across Manhattan's prime districts. Property owners whose assets neighbor seized Trump buildings face immediate valuation concerns as federal enforcement creates uncertainty in traditionally stable markets. Republican donors who maintained financial relationships with Trump Organization ventures received legal notices advising them that continued payments could subject them to federal investigation. The donor freeze affects not just campaign contributions, but business partnerships, consulting agreements, and commercial relationships that provided steady income streams. When federal authorities warn donors about legal exposure, fundraising operations face systematic destruction. Political ramifications extend beyond fundraising challenges. GOP leadership received private briefings explaining that campaign events at seized properties cannot continue. Endorsement photo opportunities at Trump venues are prohibited under federal restrictions, and any association with frozen assets could trigger campaign finance violations. The party infrastructure built around Trump properties has been systematically dismantled through judicial enforcement. Banking relationships that took decades to establish are collapsing within days. Deutsche Bank, JP Morgan Chase, and Bank of America all confirmed they are reviewing existing credit facilities with Trump Organization entities to determine exposure to federally controlled assets. Industry sources describe financial institutions as conducting emergency reviews to prevent association with operations under federal seizure. The systematic nature of this collapse demonstrates something unprecedented in American business history. We're witnessing the complete dismantling of a multi-billion-dollar organization through coordinated federal enforcement that reaches across states, affects international operations, and disrupts entire market segments. This isn't standard business failure through economic pressures. This is deliberate destruction of an empire through judicial power that recognizes no boundaries and accepts no delays. Legal experts are calling this the most comprehensive corporate seizure in modern American history. Professor of Constitutional Law at Harvard University, Margaret Chen, stated, "We haven't seen federal enforcement of this scope and coordination since the dismantling of organized crime enterprises in the 1980s. The difference is that those operations targeted criminal organizations, while this targets a former president's business empire through civil fraud proceedings." Former federal prosecutor Sarah Williams, who handled white-collar cases for the Southern District of New York, explains why Trump's appeals will likely fail. Quote, "When federal judges authorize coordinated seizures across multiple states, they've already determined that standard enforcement mechanisms are insufficient. Appellate courts rarely overturn seizure orders when lower courts demonstrate systematic evidence of asset concealment or transfer attempts." The timeline creates unprecedented pressure. Trump's legal team has exactly 72 hours to file an emergency stay motion with the Second Circuit Court of Appeals. According to sources familiar with appellate procedures, emergency stays require demonstrating immediate and irreparable harm that cannot be remedied through normal legal processes. Given that the seizures resulted from Trump's own failure to comply with court orders, legal experts consider successful appeals extremely unlikely. December 20th represents an even more devastating deadline. Federal courts have ordered Trump to provide complete asset disclosure, including all domestic and international holdings, beneficial ownership structures, and financial arrangements that could affect seizure proceedings. This isn't a request for voluntary cooperation. This is a court mandate with contempt of court penalties for incomplete or inaccurate information. Banking industry experts are describing the financial institutional response as unprecedented flight from potential liability. Former Chase Manhattan executive director Michael Rodriguez stated, major banks are conducting emergency reviews of all Trump-related exposure because association with federally seized assets could trigger regulatory sanctions and reputational damage that no financial institution can afford. Real estate valuation specialists confirm that forced liquidation of Trump properties will create market disruption unlike anything Manhattan has experienced in decades. Certified appraiser Jennifer Martinez, who specializes in luxury commercial properties, explained, when courts order immediate sale of premium real estate to satisfy judgments, market values typically decline 25 to 35% below normal sale prices. We're talking about potential losses of $800 million to $1.2 billion in asset values. Political analysts are describing the campaign implications as a death spiral that no modern candidate has survived. Georgetown University political science professor David Thompson stated, running for president while federal marshals control your properties creates an impossible messaging challenge. How do you project strength and competence when courts are systematically dismantling your business empire in real time? The coordination between state and federal authorities demonstrates systematic preparation that legal observers find remarkable in scope and efficiency. Former Assistant Attorney General Lisa Park explained, this level of interagency coordination requires months of planning, shared intelligence, and judicial pre-approval that suggests authorities anticipated exactly this enforcement scenario and prepared accordingly. International legal experts confirm that foreign governments are cooperating with U.S. asset seizure requests at unprecedented levels. Professor of International Law at Oxford University James Mitchell stated, when Swiss and British authorities immediately comply with American asset freeze requests, it demonstrates diplomatic coordination that treats this as a matter of international legal cooperation rather than standard commercial litigation. Here's what makes the expert consensus truly devastating. Not a single legal authority questioned during this crisis has suggested that Trump's appeals have merit or that federal enforcement will be reversed. University of Chicago law professor Helen Roberts stated, when judges find systematic fraud spanning decades, appellate courts defer to those findings unless procedural violations can be demonstrated. Given the extensive evidence and Trump's own admissions during testimony, procedural challenges appear extremely unlikely to succeed. The political establishment is witnessing something they never expected to see. Former federal judge Patricia Williams, who presided over complex white-collar cases for 15 years, stated, the system is working exactly as designed. When wealthy defendants attempt to use litigation delays and appeals processes to avoid accountability, federal courts have enforcement mechanisms that can pierce any defense strategy. No one is above the law, including former presidents. Banking compliance officers are receiving guidance that association with seized Trump assets could trigger federal investigation of their own institutions. Industry sources speaking on condition of anonymity report that major financial institutions are severing relationships with Trump-related entities to prevent regulatory exposure. When banks flee from association with your assets, appeals become irrelevant because operational funding disappears regardless of court outcomes. This seizure establishes a precedent that will fundamentally change how accountability operates for wealthy defendants who believe litigation delays can defeat justice. Federal courts have demonstrated that systematic fraud triggering multi-billion-dollar judgments will face immediate enforcement regardless of defendant wealth, political status, or appeal strategies. Future white-collar defendants can no longer assume that appeals processes provide sufficient time to conceal or transfer assets. The implications for 2024 create an impossible political scenario that no presidential candidate in American history has attempted to navigate. Trump must campaign for the nation's highest office, while federal marshals control his business empire, courts liquidate his properties, and judges evaluate his compliance with asset disclosure orders. Political strategists cannot identify messaging frameworks that project presidential competence, while core personal assets face systematic government seizure. International observers are recognizing this enforcement as validation that American legal institutions can hold powerful individuals accountable when evidence warrants aggressive action. Swiss banking authorities, British financial regulators, and European Union legal experts have issued statements praising the coordination and efficiency of U.S. judicial enforcement. When international allies view domestic accountability measures as strengthening rather than undermining American legal credibility, the global implications extend far beyond individual prosecution. The broader message being transmitted through this enforcement reaches every wealthy individual who has used financial complexity to avoid consequences for systematic wrongdoing. Federal courts are demonstrating that decades of successful litigation delay tactics have limitations when judges conclude that defendants are actively evading rather than legitimately appealing adverse rulings. Standard wealth protection strategies become irrelevant when courts authorize immediate asset seizure.